Blake Lively made threats against Justin Baldoni, and that's okay. He was not extorted, and he was not defamed by anyone. That is what the judge ruled today when he tossed out all of his claims. Hello, my fam. It is Perez, the queen of all media, the original influencer, and your number one source for everything It Ends With Us saga. The judge is allowing the Baldoni Wayfarer parties to file a second amended complaint if they want, but the judge will only allow 2 of their claims to move forward. 2 of 9. The other 7, done. I've already made several videos about this today. Watch those to be fully caught up. In today's ruling, the judge spent a good amount of time talking about defamation. According to the judge's ruling, the allegedly defamatory statements are statements to the effect that the Wayfarer parties engaged in, permitted, and or failed to prevent sexually inappropriate conduct toward Lively, and 2, the Wayfarer parties retaliated against Lively and others for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. The Wayfarer parties allege that Lively, Sloan, and Reynolds engaged in a conspiracy to spread these defamatory narratives to the Times, other media outlets, and Baldoni's agency, and that the Times committed defamation by publishing the same narratives. These allegations fail to state a defamation claim. If this man did not do these things, that clearly seems like a solid defamation claim to me. Oh my God. It's still crazy that the judge decided all of this without a jury trial. The judge says he used California law to come to his ruling. And in California, defamation constitutes an injury to reputation by false oral or written communication. Under California law, the tort of defamation involves a publication that is false, defamatory, and unprivileged, and that has a natural tendency to injure or that causes special damage. In addition to the false accusations, Baldoni and parties asserted in their first amended complaint, quote, that Lively, Sloan, and Reynolds worked together to advance a fabricated narrative in the press that the Wayfarer parties had sexually harassed Lively, then embarked on a calculated and malicious smear campaign to destroy her reputation as retaliation for daring to complain about the harassment. This general allegation has multiple facets. Most prominently, the Wayfarer parties allege that Lively, Sloan, and Reynolds worked together to spread a false narrative to the Times. In addition, the Wayfarer parties allege that as part of the same conspiracy, Sloan and Reynolds individually made false statements about Baldoni to other press outlets and Baldoni's agency. The Wayfarer parties have not adequately alleged a defamation claim as to any part of the purported conspiracy. The Wayfarer parties have not adequately alleged that any false statements were made to the Times other than the statements in Lively's CRD complaint, which were privileged under California law. So, because all that was in her initial complaint to the state of California before she filed her lawsuit, and because the New York Times reported on that privileged complaint, all of these parties can't be held liable for defamation. Additionally, the judge claims there is no allegation that the distribution of the CRD complaint was made by anyone other than Lively, or more particularly with the involvement or agreement of Sloan or Reynolds. The Wayfarer parties have not adequately alleged that Sloan or Reynolds individually did any more than repeat Lively's version of events, which they had no reason to doubt. And the Wayfarer parties have not adequately alleged that Lively should be held responsible for Sloan or Reynolds' statements. Their allegations of a conspiracy between the parties are conclusory. Then the judge goes more into detail with regards to the New York Times And he says a fundamental obstacle is that the Wayfarer parties do not plead and may not know exactly what, if anything, the Lively parties and the New York Times communicated to each other. And they may never know that because of certain protections in the law for journalists. The amended complaint instead relies on inferences from the fact that the Times had the CRD complaint before it was publicly available and on conclusory and often dramatized allegations, sometimes on information and belief, that the Lively parties worked together to feed the Times a false narrative. Apparently based on text messages that were selective and deceptively edited, that the Wayfarer parties had responded to Lively's complaints about purported sexual harassment by plotting to destroy her reputation via a smear campaign. A plaintiff who is unable to plead direct facts must at a minimum plead circumstantial facts supporting a plausible interference that the defendant's behavior crossed the line from lawful to unlawful conduct. They have not done that here, claims the judge. The factual allegations pleaded in their amended complaint do not state a claim. They support at most the plausible inference that Lively or someone acting on her behalf provided the Times with a copy of the CRD complaint and related text messages before the complaint was filed. The judge even mentions URL for images, PDFs, and videos associated with the article contain the dates December 12, December 10, and December 16, before she filed her complaint with the state of California. The article draws heavily from Lively's CRD complaint. It would have taken time to review that complaint and its attachments. In addition, source code for a portion of the article contains the date October 31st, 2024. And because the Times had access to the CRD complaint before it was filed and while it was still confidential, there also is a powerful inference that it was provided by Lively or by someone on her team. And the judge doesn't care. He says the act of providing the CRD complaint to the Times is not sufficient to constitute defamation because the complaint is protected by the fair report privilege. The fair report privilege applies to Lively providing the complaint to the Times because it is a communication to a public journal of statements said in the course of a public official proceeding. Under California law, a party need not wait until a legal document is formally filed before providing it to members of the press. The judge says the amended complaint alleges that the Times had access to a plethora of communications demonstrating that Lively's narrative was not true. But if Lively provided messages to the Times reflecting that a smear campaign was not waged, that would not be defamatory of the Wayfarer parties. Additionally, the Wayfarer parties assert, as litigants frequently will assert, that the version of events recited by their adversary is selective and does not tell the whole story. But the claim that the CRD complaint painted a deceptively favorable picture in favor of Lively and took quotations out of context does not deprive Lively of the litigation privilege. A litigant is not required to file a balanced pleading before an agency or in the court. She is permitted to marshal the facts to tell her side of a contested story. The Wayfarer parties also show no facts to support their insinuations that Lively, Reynolds, or the Sloan parties made other unspecified communications pressing their version of events. And with regards to the whole sexual predator, sexual harassment statements that Leslie Sloan made, the judge rules that Leslie Sloan did not defame Justin Baldoni because she had every reason to believe her client and friend, Blake Lively. Once Sloan credited Lively's account of the facts, she also could have reasonably and not recklessly concluded that Baldoni had engaged in sexual assault, the judge says. And there is more to this all. Stay tuned for another video as we try to wrap everything up in the It Ends With Us saga. Until then, let's discuss all we've learned in the comments section.